So we have one item left on our business agenda, and it's a discussion regarding the proposed tenant protection program. And who carries forth? Ms. Ramirez.
Good evening, Madam Mayor,
Good evening.
council members. My name is Jen Ramirez Robson. I'm a management analyst in the city manager's office. And I'll pull this up here in just, there it is.
So I'll just preface this. Council had asked us to bring this to you back in April, which we did. And then council asked again to take a look at that and tonight for general discussion purposes. So much of the information you'll see here tonight is a reiteration of what we've already brought to you. Just bringing it back to you as your direction. That's what you see before you tonight. And Jen will give you a real high-level overview, and might be best just to entertain questions and hear the discussion among council members.
Thank you. I'll start off by saying that most tenants who rent a place to live come under the state's Residential Landlord-Tenant Act, which was adopted in 1973. And all tenants have a basic rights under this and other state laws, including a right to a livable dwelling, protection from unlawful discrimination, right to hold the landlord liable for damage caused by the landlord's negligence, protection against lockouts and seizure of personal property by the landlord. This specific law also covers rental agreements, deposits and fees, landlord responsibilities, as well as tenant responsibilities. Some of the landlord responsibilities do include providing necessary facilities to supply heat, electricity, hot and cold water, to make repairs, and keep the unit in the same condition as when the tenant moved in. On the flip side, tenants have a responsibility to pay rent and any utilities that they've agreed to pay, keep the rental unit clean and sanitary, not intentionally or carelessly damage the dwelling. There's a few more responsibilities on both sides that are spelled out, but those are some examples. This act also goes into quite a few specifics on repairs, requiring the tenant to give written notice and then going through the steps of the timelines that landlords have to repair those, or to begin that, actions that tenants can take if the landlord doesn't begin that repair process in a timely manner. So this act does cover quite a bit of that information. And the way that our code enforcement officer comes into play, sometimes tenants may not know some of these things that are available to them. So if somebody calls the city, for instance, and says, my roof is leaking, our code enforcement officer, he will go and inspect the unit, and if he sees, yep, it's leaking, he'll talk to the landlord. There's some research, and a lot of times they can either help get that process going, or if the landlord isn't responsive, there's then another process that the city can do as well that can lead to monetary penalties. So that's kind of the realm of where the city comes in. At the request of council, I also looked around the region at what some of our other neighboring cities are doing. The city of Seattle has created a number of additional laws regarding tenant protection. You've heard about rental agreement regulation, and that has to do with notice of intent to increase rent or increase other housing costs by 10% or more within a year. In Seattle, they're required to give a 60-day written notice. Under state law, the requirement is a 30-day notice. Seattle also has a just cause eviction law, which means that in the state, if you are renting month to month, the landlord can give you 20-day notice for any reason to vacate. In Seattle, they have a list of just causes that you can be asked to leave. It can't be for just any reason. City of Seattle, they also have a tenant relocation assistance program for evictions due to demolition, change of use, or substantial rehabilitation. Low-income residents will be eligible for an advanced relocation assistance payment of $2,000. The property owner is responsible for half, and the city pays half. And then there's also a condominium and cooperative conversion ordinance, and that also goes to relocation assistance as well. Let's see, actually, I'll move forward there. The city of Tukwila also has a relocation assistance, and in an instance where the city of Tukwila has condemned or deemed unlawful to occupy a dwelling in the city of Tukwila, and if they are eligible, the city will advance up to $2,000 to eligible tenants to relocate, and then the city will go after the landlord to be reimbursed for that, and that's in accordance to state law. And that state law came about after the Juanita apartments that happened here in Burien. And a lot of these, I'll point out, are reactive, and this is modeled, after the state, but a lot of these others are reactive. They're based on a tenant or a landlord complaining or doing something. There's also a couple of programs around the state that are a little bit more proactive. The City of Des Moines, they have a crime-free rental housing program. They require that every rental housing facility undergo a crime prevention through environmental design walkthrough. And this is around the perimeters of units to identify areas that may pose security or safety issues. So they have their code enforcement office. Someone will go out and inspect the units, and from the outside, not from the inside. And there is a fee per unit cost. When this was passed in 2005, that cost was $100 per unit, and I believe that that has gone up quite a bit since then. And that's done on a yearly basis. Then there's a rental licensing program in the city of Pasco. This is one that has had a number of lawsuits, and they've won them, and the city has been able to uphold this program. They require that all rental units must be licensed, registered, maintained, inspected, and certified every 2 years. And property owners, they have about 6 options of who does those inspections, but they are required every 2 years, and that is inside as well as outside. And then last, the city of SeaTac, they've actually tried to work directly with property owners through an apartment managers network. They have held quarterly, usually lunchtime forums to promote continuing education and networking and information exchange. I did recently talk to someone at the city of SeaTac, and they have said that it's been quite challenging to bring this group of folks together. And a lot of it is, in a recession especially, they don't like to leave the property if they can get somebody to rent a unit. And lastly, I'll point out Washington State Attorney General's office does have quite an extensive brochure. One of the things that the cities of Tukwila and Kent have done is they have modified that. They've condensed it down. It's a little bit easier to understand, and they've combined that with local resources, city numbers, so it's a little bit more tailored to the city itself, and they do have those posted on their websites. And with that, I believe that covers the information that has been presented previously, and I'm open to any questions.
Councilmember Kukoviac.
Thank you, and thank you for bringing this to us in a timely manner. I want to start the discussion by asking what the City of Burien is currently doing. So I know we have a crime-free voluntary program with apartments, and could you fill us in with information on that, and how is that going?
Well, the crime-free housing, they have property owners go through a program, and that teaches a lot of those environmental things that they can do around their property, whether it's through lighting, how they can, what their rights are as far as eviction, and those sorts of things to help keep their properties safe and healthy places to live. And they are given, I believe it said discount? Okay. On future registration and tax.
I think, as Jen mentioned, the short story about the way we do this in Burien is that, as she said, it's reactive. So my roof leaks. It's not enough that your roof leaks and your landlord is unresponsive. You call the city, we send a code enforcement officer. The tenant has to let the code enforcement officer inside the building. He takes pictures, he contacts the landlord, tries to get some action there. No action occurs. There are a series, an escalating financial penalty that they can be assessed. If that's ignored, there is a procedure that ends up in Superior Court that could potentially eventually put a lien on the property and cause the fix to be imposed. And that's fairly standard for most cities. It's true in Burien. Certainly it's reactive. It's not proactive in the sense that Pasco or the City of Seattle or some of these others have it, but Jen described that correctly. So I think the question here, that framing it for council, would be that does council want to stay with that sort of reactive model, modify it, go to a proactive model, leave it alone? That's generally the nature of things. But the voluntary program that Councilmember Krakowiak asked about is by no means an aggressive, proactive model, if that was the question.
Any further comments?
Yep, I do have.
Okay.
But if someone else